Yeah, we don't. Morning, Becky.
You can have the Joe bring her in whenever. Hold on, Mr. Davenport, I'm looking for your paperwork. All right, so this is in the matter of Nicole Marie Howell versus Christian Robert Davenport, file number 2019-46565 DM. I have Mr. Davenport appearing via Zoom. Sir, it states here you're ordered to pay $411 a month in child support. And as of today's date, we have an arrearage in excess of $2,955. So this is the 19 file. It says here we've never received a payment. Our original show cause was set on October 3rd because there was a referee hearing. The referee hearing got dismissed. All right, Mr. Davenport. So in your case, the child support order was entered. Do you understand that if your arrearage reaches a certain level, you'll be charged with a felony and be facing up to 4 years in prison? Do you understand that?
Yes, ma'am.
Do you have any felonies?
No. I've been trying to get a hold of our support enforcer. I cannot get anybody to return my calls or get back with me. I'm currently unemployed at the moment. They went based off of the PUA that we were receiving.
So hold on a second, Mr. Davenport. You had a referee hearing. What happened at the referee hearing?
You got dismissed and all
right, guys. This courtroom hearing begins with what appears to be a routine child support enforcement case, but the stakes quickly become much more serious. The judge calls the matter involving Nicole Marie Howell and Christian Robert Davenport, confirming that a standing court order requires Davenport to pay $411 each month in child support. The court then reveals that his unpaid balance has climbed to more than $955, with records showing almost no payments since the order was entered. As the judge reviews the history, she immediately warns that continued non-payment could eventually expose him to felony charges carrying the possibility of prison.
All right. She said that neither one of us had, I don't know what happened, to tell you the truth, Your Honor.
Okay.
The lady said that
I cannot here today adjust or modify your child support. Your child support's entered at the time your order was entered, at the time of your divorce, probably. If you had an objection, you had to file the objection back then, or you can ask for an income review, but that's something you have to do through friend of the court. That is not in front of me right now. Do you understand that?
Yes.
Okay, so Mr. Davenport, once again, do you understand that if you fail to pay your child support and your arrearage gets much bigger, you could be facing a felony and incarceration? Do you understand that?
Yes, ma'am.
All right, so how much can you pay on this today?
I just put $80 on it just like 10 minutes ago.
Okay, and are you working?
No, I just said I'm currently unemployed. I'm looking for work. I just got a vehicle going.
So, Mr. Davenport, one of the things I can do is require you to show proof of search of employment weekly and report. Is that something you want to have to do?
Not really, because I'm self-employed.
Okay. Another thing I'm going to tell you, Mr. Davenport, if you're self-employed and can't afford to pay your child support, then you need to get a different job. So I have people that work, a second job to pick up and pay off their arrearage. But Mr. Davenport, being self-employed is not an excuse for not paying your child support. So, Mr. Davenport, I'm going to adjourn this for 2 weeks for you to make a $400 payment. And I'm going
to The tension rises as Davenport explains that he has repeatedly tried to contact child support enforcement, but claims no one returned his calls. He also tells the court he is unemployed and says the original support calculation was based on temporary pandemic assistance rather than his current financial reality. But here's where everything changes. The judge makes it clear that today's hearing is not about changing the amount of child support. Instead, she explains that any request to modify payments had to be filed through the proper legal process, and ignoring the existing order is not an acceptable option under the law.
And I'm going to require you to come in person. Do you understand that?
I didn't catch that last part.
So I'm going to adjourn this 2 weeks for you to make your full well, $400 payment, and I'm requiring you to come in person. Do you understand that?
Come in person to make the payment?
No, I'm going to require you to make the payment, and then I'm going to adjourn our next hearing, and the next hearing will be in person. So you physically have to have your body in my courtroom for the next hearing.
Okay, and when can I request a lawyer? I mean, I do have that right? Because through none of this, I've been offered a lawyer or anything.
Well, you don't get a lawyer through front of the court.
I'm in court right now, though, right, Your Honor?
No, you don't get a lawyer to do an income review, but if you want me to, I wasn't even gonna ask you to plea, I was just gonna give you an opportunity to make the payment, but, I can't
Well,
offer you a
I
court-appointed
have no
attorney.
income, and
I
I'd like to talk to somebody. I'm doing all this on my
So,
own.
Mr. Davenport, okay, so I'm gonna arraign you officially. I was giving you an opportunity to make your payment. But Mr. Davenport, do you understand that it's a crime to fail to pay child support?
I understand that, Your Honor. I mean,
Do you
I'll do my
understand that
best.
if I find you guilty of failure to pay child support, you could be facing up to 45 days in jail? Do you understand that?
I'm going to do my best to make the payment, Your Honor.
Do you understand that? It's a yes or no, sir?
Yes.
Do you understand that you do have a right to have
Now
an
the courtroom
attorney?
atmosphere shifts dramatically. When asked how much he can pay, Davenport says he recently managed to send only $80 and insists he is still searching for steady work while trying to remain self-employed. The judge responds with a firm warning that self-employment does not excuse someone from meeting court-ordered child support obligations. She explains that many parents take second jobs when necessary and announces that the hearing will be postponed for 2 weeks, expecting a $400 payment before requiring Davenport to personally appear in court for the next
You do
hearing.
have a right to have an attorney represent you only on this, not on your child support case. They can't go to court with you to try to get it reduced. But on the whether or not you have failed to pay your child support, do you wish to have an attorney appointed to represent you at this?
No, I'm going to do my best to get the payment in there, and I'll be in for the next hearing.
So I only appoint attorneys on the issue of whether or not you have failed to pay child support, not whether your child support is set at the correct number. So we can't appoint an attorney for like a referee hearing or an intake hearing. We just do it on this. Like, so 1, did you make your payments? If you didn't, you're probably guilty. 2, if you did, you know what I mean? That's what we do.
All right.
Okay, so do you want an attorney on this today?
No, we should be good.
Okay, so I'm going to set this over, Ms. Adams, let's do November 21. And I'm gonna require you to come in person, okay?
Yes.
All right, so we'll set this over to November 21 at 8 a.m. Sir, this is your notice. You'll get one in the mail, but I'm also giving you notice on the record, so write it down. November 21, 8 a.m. and you gotta be here in person, all right?
Yes, ma'am.
All right, we'll see you back here on that day. And if you could make your $400 payment by then, I'd appreciate it. And I'll enter a plea of not guilty on your behalf. All right?
Thank you.
All right, thank you. You're all set. You can disconnect, sir. All right, Brandon Martin.
As the hearing nears its conclusion, Davenport asks whether he has the right to an attorney, saying he has been handling everything alone and has no income. Here's the real bombshell. The judge carefully explains that an attorney can only be appointed regarding the alleged failure to pay child support, not to reduce the existing support order itself. After hearing the explanation, Davenport declines court-appointed counsel and promises to do his best to make the required payment. The judge schedules the next hearing for November 21st at 8:00, orders him to appear in person, and reminds him that the outstanding payment must be made before returning to court.